APUS government students, we are back. Here we go. Exam 3.2 lecture. Let's talk about some more stuff with our federal judiciary. All right, so probably the most important case that comes along in our country's history happens in 1803. All right. So many of you know I went to law school and we spent pretty much our whole first week dissecting this case, the facts, the holding, the importance of it. You know, my con law professor was huge about Marbury versus Madison. All right. I'm going to give it to you in just a couple minute nutshell. All right. This is one of those cases where the facts, though they are important, I think they can be pretty confusing because they get to a lot of different things. And yes, it's Madison, the Madison that we know about that's involved in this, and Marbury's involved in this too, a guy named William Marbury. So we're just kind of I'm going to gloss over those, other than to get us to recognize that the Supreme Court and Chief Justice John Marshall are looking at what they believe is a law that seems to go against the U.S. Constitution. So what do? We've got a law passed by Congress that goes against the U.S. Constitution. So what do? I mean, there's nothing in the Constitution really about what to do. And so what Chief Justice John Marshall and the justices do in their brilliance in Marbury versus Madison is, in essence, create this idea of judicial review. Now, as we've talked about, it was not necessarily a new concept. All right, it was talked about by our founders. It was talked about by Alexander Hamilton in the Federalist number 78. But just because it's in the Federalist number 78 doesn't mean anything. It has no power of law, no authority in our country. It creates no precedent. But once Chief Justice John Marshall finds this case and is able to establish now this power of judicial review, poof, we now have it since 1803 until today. And it's our judiciary's biggest power that they have. This ability to look at laws, state laws, city ordinances, federal laws, versus the Constitution. And what they say is everything has to follow the Constitution. Why have a Constitution if we're going to create laws that go against it? For example, why have gun rights if you're going to have a state that says, in essence, no guns for anybody? Well, that goes against the Constitution, right? I mean, blatantly. So we're going to have this power through judicial review to review these laws and, in essence, rip them up, throw them out, declare them null and void if they believe it doesn't follow the Constitution. Now, this is fairly rare, all right? Cities, states, the federal government, I mean, they know what's in the Constitution. It doesn't happen very often where we're throwing out laws, but it certainly does happen. It does happen, and we'll continue to talk about that. There's been a number of state laws that have been thrown out. There have been some federal laws that have been thrown out. There have been some city ordinances that have been thrown out that we'll talk about throughout the semester. But here it is, the result. All laws must follow the Constitution. And it's the court, they declare upon themselves, we're the branch to do this. This is us. We are the ones. And Marbury versus Madison declares it. Yes, it has links to the Federalist number 78, the most powerful, important case of our judiciary's history, this power of judicial review from Marbury versus Madison. All right? Hierarchy of laws. So this, in essence, sort of creates this hierarchy of laws. It establishes that the U.S. Constitution is king. These are super laws in how they're created and how they're followed, and that our Constitution is not subject to judicial review. Everything else must follow the judicial review of the U.S. Constitution. All right? So you can see there I put federal statutes, federal cases on the left, state statute, state constitutions, and state cases. Those things are all subject to judicial review, meaning they can be thrown out. All right? So This then harkens back to what we talked about way back in exam 1, where we talked about we passed this amendment for prohibition, all right, the 18th Amendment. The only way for a country to be able to legally drink again is to pass another amendment. You couldn't pass a federal statute. There couldn't be some case that comes along that says, oh, we're not going to follow that 18th Amendment. You have to create another constitutional amendment to nullify a previous amendment. That's the only way to do it, right? Because these amendments are not subject to judicial review, like the other things that we have on here in the bullets and arrows are. Okay? All right, moving on. Here we go. U.S. court system structure. Make sure you get this down. Important stuff here. All right? A number of things to gather from this. First, cases are going to start at either the bottom left or the bottom right, and I will teach you that here in a little bit, what cases go to federal district trial court versus what cases go to the Nebraska trial courts. All right? Some other things to gather here. Congress says, we talked about Congress's power with our federal courts. Every state is going to have at least one federal court. So every state is going to have at least one federal district trial court. Now, some will just have one. Others may have dozens, depending upon the population and size of the state. All right? And then I'll talk about, if we just focus here on the left-hand side, the red, I'll talk about the number of federal court of appeals that we have within our country. So cases that are appealed from the federal district trial court can go to there. And then a very small number of cases we'll talk about will go to the United States Supreme Court, usually less than 100 each term. All right. If we then go to the right-hand side, cases can start at a Nebraska trial court level. All right. We do have a Nebraska appellate court level, but I kind of skip over that for us. Then we have the Nebraska Supreme Court. So every state has a highest Supreme Court, or whatever it is that they want to call it, in their state. All right. But then you can see the United States Supreme Court has jurisdiction over all of those cases as well. All right. So if the Supreme Court is going to reverse a law, throw out a law, it usually has been a state law. Sometimes they'll throw out a federal law, but that's been pretty rare in our country's history. All right. All right. Review scenario here. So make sure you get this down. All right. So it breaks Nebraska laws. So it's going to be state court. It's going to start a trial. So if we go back to our map then, on the right-hand side, Nebraska trial court, Nebraska Supreme Court, U.S. Supreme Court. All right. These cases do not cross. I talk about don't cross the streams. Don't cross the streams. A case may not go from the Nebraska trial court to the U.S. federal appellate court. That's just not the way that the cases move. The lawyers want to use a similar case with similar facts, precedent. The chances of it going to the U.S. Supreme Court, as we'll talk about in a later lecture, very small. About 0.5% chance of going to the U.S. Supreme Court. All right? Okay. A lot here for us here in 3.2. Here's our jurisdictional key. So what is jurisdiction? Jurisdiction is the authority of a court to hear a case and provide a remedy sought. So I've got 3 federal district trial court keys. I call them keys because they unlock the door to the federal courthouse. All right? And we're really going to focus on 2 of these 3. Primarily number 3, a little bit of number 1, and not really at all number 2. I just mentioned it there in passing. All right? We have some, though not a lot, comparatively speaking to the states, federal criminal statutes. And I'll be very clear if I'm giving you a scenario of someone breaking a federal criminal statute. Otherwise, I want you to believe that it's going to be a state criminal statute. That's kind of your default. State criminal statutes, that's your default. Most states, strike that, all states cover their criminal statutes, all right, from A to Z and in between, all right? They are the primary driver of criminal statutes. Then the federal government overlaps some as well, just a little. You can see those instances there. I'm going to skip over 2 and 3. This is the big one. Of all the cases that we're going to look at that have a chance to go to the U.S. Supreme Court, they're going to be about federal diversity. All right. When I talk about getting to the U.S. Supreme Court, I mean cases that will start at the federal district trial court level and go up through that left-hand side. Federal district trial court, federal court of appeals, U.S. Supreme Court. Most all of those cases that we're going to look at are going to have what we know as federal questions in them. They're going to deal with an issue of the U.S. Constitution, the amendments, or federal laws. And then from there, very simply, default, if it doesn't fit into one of these 3 keys on the left, it is going to go to the states. They're going to have jurisdiction over everything else. So who hears the most cases? Your state courts. Much, 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 much more. Dozens, 5, 10, 20, 30 times the amount of judges on your state court side versus your federal court side. All right, we just have, I think at my last check, I think we've got 2. I think we've got 2 federal district trial court judges in Nebraska. I think it's 2, and then there's 1 on senior status, so he hears a few cases. So it's kind of like 2.5 versus hundreds of Nebraska state court judges. All right. Last part of this lecture here is looking at policymaking and the courts. All right. The likeliness to strike down laws, that's judicial activism, an active role. Judicial restraint, a restrained role in throwing out laws. So how apt is that judge in utilizing judicial review? A lot or a little? And those are those 2 differences. All right. The final thing then here for 3.2 is strict versus broad construction. And I could go on forever about strict versus broad construction, but I'll give it to you here in a nutshell. Different judges have different beliefs about interpreting things like the Constitution. All right, a strict constructionist is going to say, hey, what did they mean when they wrote that amendment, that part of the Constitution at that moment in time? So we look at, and we'll talk about the 14th Amendment a lot. That's an equal protection clause. So what a strict constructionist would say, now stay with me here, is when that was passed in 1868, which it was, all right, that amendment came out of the books, a strict constructionist would say, what did they mean at that moment? What were their meanings, their interpretations of those words at 1868? And we lock them in. We write them in stone, and we don't ever allow for any changes in that interpretation. We have this strict construction, strict belief of that constitutional amendment. What a broad constructionist would say is, whoa, we can look at the broader intent, the broader purpose. So like with the 14th Amendment, that has been a very controversial amendment from a construction standpoint because it was written at a time in 1868 it was about, African Americans and providing them equal protection. That was the group. That was the group. All right, that it was intended for. And strict constructionists would say we lock that in and that's the group. Whereas broad constructionists would say, well, no, we can look at other minority groups over time. African Americans then, gays and lesbians now, maybe potentially, who knows, we'll see. Transgender folks now into the future, we'll see with future cases. But we'll take a look at a few cases, primarily this one here at the end of this lecture, Obergefell versus Hodges, that ties into construction, strict or broad, and this 14th Amendment. All right, I know that was a lot. That's 3.2.